Negligence. Negligence is analyzed under an objective standard by comparing defendant's actions to a reasonable person under the same or similar circumstances. The elements include 1. Duty of care. Defendant owes a duty to plaintiff to conform to a specific standard of care. Reasonably prudent person. Defendant's duty is to behave like a reasonably prudent person under the circumstances presented. An exception in certain situations is an alternative standard of care applies. 2. Breach of duty. 3. Causation, which include the actual cause and the proximate cause. The MBE may refer to actual cause as cause in fact or factual cause, and proximate cause as legal cause. 4. Damages. Duty of care. Defendant owes a duty of care to behave like a reasonably prudent person under the circumstances to all foreseeable plaintiffs. Default standard of care is a reasonably prudent person. Defendant's duty is to behave like an ordinary, reasonably prudent person under the circumstances with regards to foreseeable plaintiffs. The reasonably prudent person is considered to be someone the defendant's physical characteristics, including disabilities such as blindness, but with the knowledge and mental capacity of an ordinary person. Foreseeable plaintiffs, those within the zone of danger. The zone of danger is the area around the defendant's activities in which a plaintiff could foreseeably be injured. Rescuer's exception is if defendant puts himself or another in danger and a third person attempts to rescue. Defendant can be held liable for the rescuer's injuries, even if unforeseeable. Does not apply to emergency personnel such as firefighters or police if their injury results from a risk inherent to the job. Prenatal injury. A duty of care is owed to a viable fetus. Specialized standards of care. Children are held to a standard of care of reasonable child of a similar age, education, intelligence, and experience. Generally, young children under 6 or 7 lack capacity to be held negligent. Adult activities exception. Children engaged in adult activities must conform to an adult standard of care in that activity. Common carriers and innkeepers are held to the utmost care and standard, liable for even slight negligence to passengers or guests. Custom or usage in an industry can be used to establish a standard of care, but failure to adhere does not automatically give rise to a breach of duty, nor does compliance with an industry custom automatically establish a lack of negligence. Professionals must act with the knowledge and skill of a member of their profession in good standing in similar communities. Medical professionals are held to the national standard of care. An existing statute may establish a standard of care in which case, the statutory standard imposed by the statute will replace the general common law standard of reasonable care. Requirements are that the statutory standard of care will apply if statute satisfies 3 criteria. 1, plaintiff must prove that harm suffered is a type the statute was meant to prevent. 2, plaintiff is in the class of victims the statute was meant to protect. And 3, the statute applies a standard of conduct which says what to do and what not to do. Statutory standards of care does not apply if A, compliance is more dangerous than non-compliance, or B, compliance is impossible under the circumstances. Negligence per se is a violation of a statute means plaintiff must only prove causation, not breach of duty. Under the majority rule, that violation of the statute establishes conclusive presumption of duty and breach of duty. Compliance does not automatically clear defendant of liability. Owners and occupiers of land may have a duty of care for anticipated trespassers and child trespassers. Same standard of care applies for owners and occupiers. Unknown or undiscovered trespassers, there's no duty owed. Anticipated trespassers, where owner has a reason to believe a trespasser is on our land. These activities, owner has a duty of reasonable care in carrying out activities on her property. Dangerous conditions, the owner has a duty to make safe or warn of any known, concealed, or man-made hazards. This is rare. Look for spring guns, traps, etc. The attractive nuisance doctrine for child trespassers, owner must make reasonable care to eliminate dangers on her property or protect children from dangers if 1, she is aware or should be aware of a dangerous condition on the property. 2, she knows or should know children are in the vicinity. 3, the condition is likely to cause injury given a child's inability to appreciate the risk. And 4, the magnitude of the risk outweighs its utility or the expense of remedying it. Licensee is one who enters a land with owner's permission for his own purposes or business, not for the landowner's benefit. So this could be relatives, friends, or social guests. An invitee is one who enters land held open to the public or who enters with the owner's permission to confer a commercial benefit. This could be a store owner, a concert goer. The duty of care owed. Activities carried out on a property, reasonable care. Known or dangerous conditions, duty to make safe. Duty to inspect is not applicable for licensees. Invitees, owners have a duty to conduct a reasonable inspection for non-obvious dangers and make them safe. May be non-delegable. So businesses that hold property open to the public have a non-delegable duty to keep the premises safe for customers. Scope of duty. This is limited by scope of invitation, licensee. Owner's duty extends only to those areas where one is an invitee or a licensee. Store owner does not owe duty of care in employees only areas. And note, police and firefighters are considered licensees but cannot recover for injuries suffered in the line of duty if the injury results from a risk inherent in the job.